Joining me is Kevin Gosztola. He's a journalist for FireDogLake.com. He's been covering the Wikileaks story, Bradley Manning, and secrecy, et cetera, et cetera. Kevin, I think a good place to start is, what is the status of Bradley Manning today? Where is he? What is his legal status, et cetera?
Well, currently he's being held at Fort Leavenworth in Kansas. The status is that we have a trial date for the beginning of June. Right now on the calendar, the next hearing, he's been having regular motion hearings just about every month, which I've been covering at Fort Meade, Maryland, where they've been having the court-martial proceedings. And the next motion hearing is scheduled for the end of February through to March 1st. And what we expect to hear at that hearing is a ruling on the speedy trial motion that the defense filed.
And who's representing him?
His lawyer's name is David Coombs. He's a civilian lawyer. He has a background in the military, but he's no longer serving in the military. And then Manning has a couple other military trial counsel defense lawyers that are representing him.
What was the basis for the decision to move Bradley Manning from Quantico to Kansas?
This really happened because there was a lot of media attention and outrage about how people believed he was being treated at Quantico. We've now had a judge rule that he was unlawfully punished when he was held at the Quantico Marine Brig. And there was a major hearing at the end of November, the beginning of December, where Bradley Manning himself actually testified. And we had people from the whole chain of command at Quantico come and testify about how they handled Bradley, because the government had a burden to show that they had a good reason for the way that they treated him. And in the end, the judge found that he should be awarded 112 days sentencing credit. That's not a lot, really, when you think about the fact that he could be sentenced to life in prison without parole. But she recognized that there was unlawful punishment.
So let's talk a little bit about that. Gets us into the next question, which is, when we hear reactions to how Bradley Manning is allegedly being treated, and people will say, oh, I think that that's either fair or unfair, it seems important to kind of put it into context of what would be standard operating procedure for a comparable case, a comparable individual. Where does that come down?
We have a case involving military justice, so it's slightly different than when you would be talking about a civilian. However, I guess you could draw parallels, because currently there is this climate that is generating much support for, at least along the political class. I can't really speak for citizens exactly, but in looking closely at the political class of this country, you can see that from that area and within intelligence agencies and in government and in the Obama administration, you've got an unprecedented war on cracking down on leakers and going after whistleblowers. And so it seems to fit, just the way that Bradley Manning has been treated, it seems to fit within this trend.
Now, what about within the legal framework? I mean, in the sense that it was determined, and that's why Bradley Manning was given the 100+ days credit, that he was not treated properly. Is it, elaborate on that a little bit. In other words, what specifically in how he was held was determined to be inappropriate?
Well, what they were looking at were instances, for example, where a commanding officer had decided improperly that he should be sleeping every night without his underwear and have no clothing, and all he was able to use to cover himself was a suicide blanket, basically something to prevent him from harming himself. And that was deemed to have been handled improperly, so he ended up getting an award. There were times when he was placed on suicide risk, and in addition to being held in maximum custody, and the status, there was a clinical psychiatric status that he was held on called prevention of injury, and you're only supposed to be on it if you're believed to be in a state where you would harm yourself. And so on top of that, sometimes he was moved up to suicide risk, and there were multiple times where he was put on this, and the doctor said, take him off. He no longer belongs on suicide risk. And so you add up these days where he shouldn't have been confined in these conditions, and then what happens is you get the credit that was ultimately awarded. And unfortunately, the judge did not find that he had been held in conditions of solitary confinement, which I thought is something critical for people to consider, because the ACLU had a post after the ruling that showed they've been representing people who are held in solitary confinement, and Bradley Manning was kept in the exact same conditions, 23 hours a day in his cell, not able to join people for meals. He's not mixing with the group population, the general population, and so confined there and really restricted in his movement, limited time out of his cell for recreation, sometimes not even given the recreation, 20 minutes. Part of the credit actually came from the fact that he maybe should have had an hour instead of 20 minutes in many instances.
What do we know about the defense that Bradley Manning is going to mount here? In other words, what will kind of be the crux of defending himself in the trial?
Well, we know what the government doesn't want to be the defense. We know that they don't want him to talk about motive, which is why they issued a motion and the judge granted it, in part so that when he's during the trial, his lawyer won't be able to say Manning had good faith when he released the documents. So it's going to be difficult to make a whistleblower defense. And I think this is something that greatly troubles people who are supporters of Bradley Manning.
Okay, so let's stop there for a second. So is it common? So I guess there's really two questions. Is it common for motive to be used in these whistleblower defenses? And number two, is it typically effective when swaying? Will that sway a jury?
Well, my conclusion was that typically you would not be able to argue motive as part of your defense, because the military, and I don't think it's unique to the military, it probably happens in civilian courts as well. Typically, you just have to prove that you violated the code or the law,
right,
and then that's good enough for the judge. So I don't think motive typically weighs in until sentencing, and they haven't precluded it for sentencing. So you could still talk about Bradley Manning's motive during sentencing. The only problem that I see with them being prevented from talking about motive is the fact that he's charged with this aiding the enemy offense. This federal charge is very egregious, carries the possibility of being put in prison for life without parole. And it essentially, the government argues that he aided al-Qaeda indirectly by releasing the information to WikiLeaks. And it actually says that he did this to injure the United States or to advantage a foreign power. So you have to prove that he had knowledge. So this is where it's important that your listeners understand. I said granted in part because the judge said, well, during a trial, I will hear about what knowledge he would have had. Talk a little bit about his state of mind when he did engage in the alleged acts, because it matters for this charge.
So summing up, what will be probably the line of defense that will be taken, the primary line of defense?
Well, the primary line is going to be, I think it's going to be that the military let Bradley Manning down. I don't necessarily think that this is a good defense, but this is what I've been hearing from his lawyer, David Coombs. Just to say that they didn't protect and practice good information security at the forward operating base Hammer, where Bradley Manning was stationed as an intelligence analyst in Baghdad, just to talk about the ways that he had mental health issues and the military was derelict in providing him care. And I guess, it's odd because because his lawyer is basically putting on a whole mitigation defense. I mean, he's not saying that Bradley Manning is not guilty. The whole entire argument I expect to be mostly about how can we get these charges thrown out.
All right, Kevin Gosztola, journalist for FireDogLake.com. We will definitely check back in with you as the trial nears.
Thank you.